yellow. When the red light comes on, your 5 minutes has expired, and we ask that you please wrap up. I now recognize General Rokita for his opening statement.
Thank you, Chair Comer, Ranking Member Ocasio-Cortez, and members of the committee for inviting me to speak here today. It's good to see you. My name is Todd Rokita, and I serve as the Attorney General for the state of Indiana, an office where I manage over 400 employees. And prior to serving as Indiana's Chief Legal Officer, I spent several years in the private sector as General Counsel for a company that served other companies, each having over 100 employees. And before that, as you mentioned, Chair, I served as a member of Congress for 8 years as the Subcommittee Chairman on Education and Workforce, where I served under many chairmen, including the one here today. So just like then, I'm sure I'll be corrected a few times today as well.
She does that a lot.
Like I said, it's good to see everybody. I also had the honor of serving for 8 years as Indiana Secretary of State, where I managed the day-to-day operations of well, near 100 employees. So I believe these experiences, in short, give me some unique insights on how our laws regulate and restrict the use of race and sex in our workplace. You know, the United States was founded on a basic idea, as self-evident today as it was 250 years ago, and that is all men are created equal. That idea is embodied in the 14th Amendment as well, which requires state governments to provide equal protection of the laws to all persons. The Fifth Amendment imposes similar constraints on the federal government. Likewise, Title VII of the Civil Rights Act, which prohibits invidious discrimination in the workplace, advances the goal of equal treatment in the private as well as public sectors. So despite the importance our nation places on equal protection under the law, corporate America and academic institutions have all too frequently embraced the notion, completely at odds with our founding principles, that to remediate racial discrimination of the past, we must somehow engage in racial discrimination now. For decades, that misguided notion was put into practice through affirmative action programs on college campuses. More recently, it has infiltrated workplaces in the form of diversity, equity, and inclusion, or DEI, initiatives that have become fashionable in the C-suites of many of America's largest companies. Such racial discrimination ignores the observation that Chief Justice Roberts made back in 2007 that the only way to stop discrimination on the basis of race is to stop discriminating on the basis of race. In other words, eliminating racial discrimination means eliminating all of it. And that's exactly what the Supreme Court recently declared in Students for Fair Admissions. In that case, the court held that the admissions programs of Harvard College and the University of North Carolina violated the Constitution and civil rights laws because they relied on race to decide which students get admitted. The implications of the decision extend beyond the academic world because picking winners and losers based on race is wrong and illegal in any context. It follows that DEI initiatives in corporate America that require race-based hiring practices are, in most, if not all cases, likely violations of Title VII. So that's why last year I, along with 12 other state attorneys general, sent a letter to Fortune 100 company CEOs reminding them of their obligations under the civil rights laws. In our letter, we stress that these companies cannot discriminate based on race, including taking discriminatory actions under the guise of DEI. As Judge Robert Bork once said, to make a distinction between persons on racial grounds is utterly irrational. That is the bedrock, non-negotiable principle that animates all of our civil rights laws, and there is no DEI exception to that in the Constitution or in Title VII. Our civil rights laws also guarantee the equal treatment of men and women irrespective of sex. In Bostock versus Clayton County, the Supreme Court narrowly extended this principle, mistakenly in my humble view, to hold that employers violate Title VII if they fire or refuse to hire an individual because of sexual orientation or gender identity. Critically, the court's decision only concerned the hiring and firing decisions and specifically declined to address other issues that employers may encounter. To address some of the questions left unanswered in Bostock, my office recently issued an advisory opinion concerning the use of preferred pronouns in the workplace. We determined that neither state nor federal law requires a coworker to use the preferred pronouns and name of a fellow employee, and that an employer is likely not liable for a supposed misuse of pronouns. No federal court has reached and no reasonable interpretation of Title VII would support a different conclusion. So in summary, as we continue to deal with the fallout of the Bostock decision, it is of the utmost importance that we address questions like this and give employers clarity about what the law requires. I am committed to ensuring that all workplaces in Indiana appropriately balance religious liberty, freedom of speech, safety, collegiality, and productivity. And Chairman, it's just an honor to be here and seeing my friends and colleagues again. Thank you very much.
Thank you. I now recognize Mr. Berry for his opening statement.